Welcome back to HFS_finance, the channel where we dive deep into the world of finance, uncovering hidden truths, and shedding light on important topics. Today, we have an intriguing subject to discuss, an indictment that has raised questions about the application of the law and the integrity of the judicial process. So, let's jump right into it. The indictment in question bases its charges on a law that might not be applicable, raising doubts about its legitimacy. It should actually fall under the jurisdiction of the Presidential Records Act. It's essential to highlight that for the case to proceed, the judge must agree with this argument, as the DOJ indictment fails to mention any violation of the Presidential Records Act. If this crucial point is disregarded, the entire case might be thrown out even before it goes to trial. It's clear that the fault lies with the DOJ for not mentioning this relevant aspect in the indictment. However, assuming the judge proceeds with the trial under the Espionage Act, the DOJ faces the daunting task of proving that Donald Trump is not only a spy but also disclosed sensitive government information. Surprisingly, upon examining the evidence presented in the indictment, we find very little support for the claim that Trump is a spy. Much of the evidence revolves around Trump's private conversations with his lawyers, which is problematic for the DOJ. Typically, attorney-client privilege protects such discussions, rendering them confidential. In this case, Trump's lawyers were compelled to testify before a grand jury, undermining this privilege. Trump's legal team argues that this was done improperly by the DOJ, a valid argument if the DOJ failed to mention the Presidential Records Act in their actions. Thus, the case could potentially be dismissed, or at the very least, the evidence derived from these conversations might be deemed inadmissible. Such a ruling would significantly weaken the DOJ's case. Now, let's examine the remaining evidence outlined in the indictment. It primarily focuses on two specific conversations, one recorded interview with a writer and another conversation with a PAC representative. However, the prosecution's interpretation of these conversations is highly contentious. The recording in question features Trump shuffling papers and mentioning a plan of attack, stating that as president, he could have declassified it. Now, the DOJ interprets this as an admission of Trump giving away classified information. Yet, there are significant problems with this interpretation. Firstly, the context of the recording allows for multiple interpretations, and assuming the worst-case scenario that Trump was disclosing classified documents to the writer might not be accurate. We must consider the possibility that Trump was merely engaging in exaggeration, which aligns with his character. Moreover, it's striking that the DOJ fails to mention the actual document in question, casting doubt on its existence. Moving on to the second conversation, we encounter more uncertainties. The indictment refers to a conversation Trump allegedly had with a PAC representative, but there is no corroborating evidence to confirm that this conversation even took place. It may very well be a fabrication, just like the false allegations made by the crooked cop in the January 6 trial. Therefore, this second supposed piece of evidence lacks credibility. Considering the weak nature of the evidence presented thus far, we must question the foundation of this indictment. Apart from the conversations with his lawyers that might be dismissed, we're left with photographs of boxes. However, analyzing these pictures, we can clearly see that they predominantly contain newspaper clippings and photos. It seems unlikely that these boxes are related to any criminal activities. The notion put forth by the DOJ that Trump was scheming to destroy the country through the manipulation of boxes appears baseless. Moreover, if the argument revolves around the mishandling of boxes, it becomes problematic for the DOJ, as these boxes were securely stored behind a locked door, as agreed upon in a prior meeting with Trump's legal team. It's important to note that this indictment contradicts the DOJ's own previous guidance on the matter, weakening their case further. Lastly, the obstruction of justice charge against Trump seems challenging for the DOJ to prove. Engaging in rigorous negotiations with one's legal team is not illegal, and there is substantial correspondence between Trump and his lawyers demonstrating cooperation with the FBI. In fact, during the raid on Mar-a-Lago, the FBI's actions could be seen as questionable, suggesting their bad faith rather than Trump's. It's highly unlikely the DOJ will succeed with their obstruction arguments, especially considering their refusal to collaborate with Trump's legal team. This accusation of Trump being a spy requires the jury to have reasonable doubts, which, given the weak evidence presented, is highly likely to occur. Now, let's take a moment to acknowledge the unfortunate case of Walt Nauta, who stands accused of lying to the FBI. The prosecution's evidence includes a one-page transcript from Nauta's interrogation, but it's crucial to consider the context and the possibility of misinterpretation. Perhaps Nauta didn't know which specific boxes the FBI was referring to, or maybe he genuinely couldn't recall. It's a stretch to claim that this single response proves his involvement in a grand conspiracy. As the secretary, it's highly plausible that Nada may not have been aware of the contents of specific boxes. The prosecution's pursuit of Nada feels unjust and distasteful. However, there is a glimmer of hope. Nada's lawyer has filed a complaint alleging prosecutorial misconduct by the DOJ. Shockingly, it is alleged that lead prosecutor Jay Bratt attempted to bribe Nada's lawyer to convince his client to testify against Trump. This alleged collaboration between the prosecutors and the White House, offering such a significant bribe, casts serious doubts on the integrity of the entire case. Should these allegations be proven true, the judge might even consider. In conclusion, this recent indictment against Donald Trump is on shaky legal ground and backed by doubtful evidence. The core charges rely on the Espionage Act, but the Presidential Records Act likely applies instead. If the judge concurs, it would halt the case immediately. The proof of criminality is also extremely weak overall. The prosecution leans heavily on contested interpretations of conversations lacking solid context. Critical documents are unspecified. Meanwhile, claims of misconduct between DOJ and the White House raise red flags. If true, it would undermine the entire indictment's credibility. The charges against Walt Nada also appear baseless, relying on limited interview excerpts without proper context. Given the shaky foundations, any impartial jury should have ample reasonable doubt. This seems a rushed, partisan indictment that may well collapse under scrutiny. Ultimately, the outcome remains to be seen. But for justice to be served, we must examine the evidence thoroughly and avoid an agenda-driven trial. Innocent until proven guilty must remain the standard. This concludes my analysis of this controversial indictment. I hope I've provided an objective perspective on the merits and flaws of the case. Please like, share and subscribe for more independent commentary. Thank you for watching.